welcome to the leaflet. We are here with Ms. Jaising and we will talk to her about the judgment on the Bhima Koregaon incident which was given by the Supreme Court today. Hi Ms. Jaising. So why don't you start off by telling us what did the court hold today? Although the hearings were very grueling, where we saw a lot of arguments being raised, heated arguments from both the sides trying to prove their point on why this petition should not stand under the Article 32 jurisdiction of the Supreme Court. So why don't you tell us as to today what the Supreme Court has decided?
Obviously the majority judgment has said that there is no case made out to hold, to establish SIT, a Special Investigating Task Force. To that extent, of course, I find the judgment disappointing, and they take the view that every case must grind its way through the Magistrates' Court, to the Sessions Court, to the High Court, to the Supreme Court, whereas the dissenting opinion of Justice D.Y. Chandrachud says that this is a case for appointing an SIT, for the reason that the Criminal Procedure Code has no provision for appointing an SIT, so it can be only the High Court or the Supreme Court. Both courts have jurisdiction to do that. So where is the legal bar to the Supreme Court entertaining a petition calling for an SIT? The second thing he says, and he is in a minority, but there's a nuance to that, is that a case, why would an SIT be appointed? An SIT would be appointed when the investigating agency is shown to be biased. Now, for me, the most important and interesting part of the judgment is the fact that he squarely names the officers of the police of Maharashtra who, pending an investigation and pending a charge sheet, pending a challan, pending the production of evidence in court, have gone public and released letters which they rely on in the investigation to come to the conclusion that they have suddenly found urban Nakshals in every corner of the country. Now, that for him vitiates the investigation by that investigating agency. There's another reason why I would have thought the investigation is vitiated, and that is because the FIR, which was prior in point of time, was an FIR filed against Ekmote and BD for having instigated the violence, and that has not been investigated. It shows a political bias in the investigating agency. Now, is his judgment the law of the land? No, insofar as the operative order is concerned. There will be no SIT, people will take recourse to the regular courts, including the High Courts and the Sessions Court. But insofar as his observations against Maharashtra police are concerned, since they are not in any way contradicted by the other two judges, I think will hold a lot of significance as we go forward. Because for one, he has reined them in from making any such disclosures in future. Secondly, he has been critical of mainstream media who have been holding up these letters supposedly written by Sudha Bharadwaj, etc., alleging a plot to assassinate the Prime Minister. And interestingly, he did say, if there is a plot to assassinate the Prime Minister, you're not doing anything for his security by going public on it. You're not enhancing his security. So what is the purpose of this disclosure? The purpose of this disclosure is to undermine the rights of the accused person. And to that extent, I think his judgment will have an impact on other courts.
So in light of this judgment, on a practical level, we have 5 people who were arrested on the 6th of June, and they are not under house arrest. Whereas the people who were arrested on the 28th of August are under house arrest. So how does this judgment now, does it change their status currently?
What it does is it gives them the right to apply for bail in accordance with law, and I have been told that they have already applied for bail. They have also challenged the extension of the period for investigation beyond 90 days, and those petitions are pending. They will have to be decided in accordance with law.
And the house arrest?
The house arrest continues for 4 weeks, and if they're able to satisfy the court that there is no case made out for an arrest, then of course they will have to be released.
Thank you, Ms. Jaising, for the quick update. We're at the leaflet. Thank you.